share my screen. Yeah, just to acknowledge Rion, who played a key role in developing the content, and we had it looked at by a legal person just to ensure that we didn't omit anything that is important. So many of you, I think, would have been made aware that last year the Minister of Transport, Minister Shikango, sent a press release informing the country that AARTO will be rolled out nationwide on the 1st of July 2024. And of course, that's when we started really doing a lot of research and doing a lot of work, because it wasn't a lot of time to prepare for the legislation in terms of making the transport sector aware of what the regulation will entail, how do they adjust their operations, how do they incorporate driver training, HR policy. So it was quite a lot of energy that went into it. We heard yesterday, and I'll share in a minute or two, that there's apparently going to be a delay in the rollout of phase 2. But as it stands, there's no official communication from the Department of Transport. The last official communication from the minister, the one that you see on the screen, confirms that it will go ahead 1st of July 2024, which isn't that far away. But as it stands, the Amendment Act has not been promulgated, neither have the regulations. So I just need to ensure we all are aware of that, and nothing can happen until the promulgation happens. So just for some of the colleagues who may not have any background knowledge on AARTO, AARTO was initially written in 1998. That's what, wow, it's almost 30 years ago. And it came out of a partnership between the KZN Department of Transport, where all good things come from, and the Victoria State in Australia. And I think Rion was probably there at the time. And the whole aim of that partnership and project at the time was to look at transforming the approach to road safety and to look at bringing about meaningful change in terms of driving behavior. And that still very much remains the intent of AARTO. Even though we are, I think, all aware of the noise and the skepticism and some of the real challenges around implementation of the Act. It has been implemented in Tshwane and Johannesburg since 2008, although the demerit points weren't implemented, but certain parts of the Act have been going for quite some time there. So as I've mentioned, and just to, I think, quote from the Act verbatim, this is just a quote from the Act, and it's intended to encourage compliance with national and provincial legislation, and it's intended to promote road traffic safety on the road networks. And then it's also intended to encourage payment of penalties. Rion, what percentage of traffic fines are actually paid? You told me the other day, but I've forgotten.
Good afternoon to the delegates. Thanks, Oliver. Yes, when I was still employed by the Department of Transport, unfortunately and very sadly, payment rates of between 5 and 8% were lobbied, and that is indeed a great concern to all of us involved in road safety, that the current criminal justice system is not really doing what it is supposed to do.
Yeah, thanks, Rion. So it's incredible. I mean, 5 to 8% of all fines issued are recovered in terms of the fiscus benefit, and hopefully AARTO will change that. But the other big reason for AARTO is to alleviate the burdens on the criminal courts and to try offences as infringements. So all of the AARTO infringements will not be handled under the CPA, the Criminal Procedures Act, but will now be migrated to the AARTO Act. But having said that, there are still a couple of severe offences, things like drunken driving, for example, that are still deemed to be criminal acts and will therefore still be handled under the Criminal Procedures Act. So when AARTO was initially mooted, or earlier on, it was planned to be launched in phases in the country. And phase one, which if you look at what the phase one list of items were, a lot of those have not yet been concluded. The draft regulations haven't yet been promulgated. Provision of infrastructure, and there are 213 issuing authorities in all 9 provinces. And that's a big number of authorities to train, to provide infrastructure for. And these are all phase one events that should have happened. Training of traffic officers, that's currently in progress from what we hear. Signing of contracts for all the printing that's required. Setting up and testing the electronic service outlets across the country. And of course, the last 2 are perhaps most important, and this is part of government's responsibility, to conduct induction and to really conscientize the public around AARTO and the education around the process and the requirements as well. And so all of that, a lot of that rather, has not yet happened, which isn't surprising that there was an announcement which I've tried to get AARTO and the National Department of Transport to give us some formal correspondence in this regard, which I have not got yet. But what I saw 2 days ago in the Business Tech publication, they confirmed in their media release that the introduction of AARTO, which was expected, phase 2 was expected to kick in on the 1st of Feb. According to the publication, this has been postponed until further notice. So it seems that they must have some information to have confirmed that. But once we get the official document from the National Department or from AARTO, we will certainly send that out to all the delegates so you can have that in writing. Then in terms of the initial proposal, AARTO phase 3 and 4 was due to follow, and phase 3 was intended to culminate in phasing in AARTO in all remaining jurisdictions in the country. And phase 4 was where the actual demerit points would start kicking in, and the rehabilitation program, which we'll talk about later. So the Act makes provision for a rehab program, which is an intervention. We don't know yet exactly what or how or where, but the rehab program was intended to provide a resource to drivers with bad behavior and recurring violations to make them aware of the impact of bad driving and how to, I think, mitigate that high-risk behavior. So AARTO, as I mentioned, is intended to promote safe driving. And there are 3 stages from an enforcement perspective. One is you would receive an infringement notice. So if you commit a speed violation or a parking offense or a moving violation, you'll be issued with an infringement notice. And we'll talk just now about the different types of AARTO notices that can be issued based on the offense type. Subsequent to the infringement, if one ignores that, then AARTO will issue a courtesy letter, which probably isn't very courteous, but that's what they call it. And then if you are still, if you do not respond to the infringement notice and the courtesy letter, then you'll be served with an enforcement order, which is quite a final directive that will prevent renewal of one's driving license, and possibly for juristic persons and for operators, it is likely to also prevent renewal of the license disc or the operator card for the specific vehicle. And again, we'll elaborate on that in a bit. Currently, there's an 18-month window that's been allotted for any old or existing fines under the Criminal Procedures Act, that should be. So if you were thinking you've got an old fine and you're going to get away with it, I'm sorry to disappoint you. If it's in the system, you're still liable under the Criminal Procedures Act and the existing processes for that. From a legal perspective, there are two acts in relation to what we're chatting about today. The AARTO Amendment Act, which we have a good idea of what the contents are, but await promulgation. The National Road Traffic Act, I think most of us on this platform, quite familiar with. It prescribes regulations that are intended to govern safety, both in terms of operational safety, safety of the vehicles, and administration that is required in achieving both of those. Okay, there is a hand up. Rian, go for it.
Thank you, Oliver. I think one of the acts that are quite important in the entire process, which we may have omitted when we developed these slides, is the NLTA, National Land Transport Act, which will also have an impact on how operators respond to AARTO. So that is an important act that plays a big role in this AARTO environment.
Sure. Rian, so from the NLTA, just out of interest, there's a number of commercial fleets present here today. How do you see the NLTA having the biggest impact in terms of commercial fleet operations?
In terms of the NLTA, and I'm not 100% au fait with that specific act because we had specialization in the Department of Transport in terms of the application of that act, but it gives law enforcement officers more powers in terms of impounding vehicles.
Right, okay.
Yes, until admission of guilt currently are paid, etc., etc. So many of those offences in terms of the NLTA, for which there are currently no admission of guilt, will still be dealt with in terms of the criminal justice, the existing criminal justice system. So we just need to be aware of it, that the seriousness of some of those violations in terms of the NLTA will not be transferred to the AARTO legislation.
100%. And we saw that play out at the city of Cape Town, I think a few months ago, when they were impounding taxis that were deemed to be unsafe. I'm sure you all remember that. And in that case, I remember clearly they used the NLTA to execute impounding the vehicles. But we will certainly, I think, incorporate that, Rian, in the next slide, just to make people aware, even though I think it's not going to have a massive impact for the AARTO, most of the AARTO demerits, but we still should include that going forward. Then the other two players in terms of AARTO and the NRTA are ARTIA. ARTIA are a division of the National Department of Transport that have been created especially to administer or administrate the AARTO Act under Section 3 of the Act. And the RTMC, or what we all know as the Traffic Police, are responsible for implementing the National Road Traffic Act and for ensuring adherence to it. So ARTIA is an independent adjudicator in terms of Section 3 of the Act. And this is taken again from the verbatim. The intention is to resolve road traffic fines fairly through decriminalization and through an admin process. And they also, in terms of the Act, are mandated to ensure that transgressors are penalized and that repeat offenders are punished appropriately. Now, the one thing which strikes me whenever I do these presentations, and I think many folk would find it odd, as I do, in terms of AARTO, you're deemed to be guilty until proven innocent, which is converse to the Criminal Procedures Act. In the Criminal Procedures Act, you are deemed to be innocent until proven guilty, and that looks at substantive and procedural fairness in terms of the Act. So this is actually quite a it can be seen as quite unfair, because the minute you get an infringement notice, AARTO and AARTO deem you to be guilty, and the onus is now on the motorist or driver to prove their innocence. And we'll show you how that, what framework exists for one to go about that. The RTMC, again, the traffic police, as most of us know them colloquially, are the lead road safety agency in the country, and their job is to protect the citizens and to ensure the roads are safe, and to engage in whatever platforms and initiatives to promote road safety. So, who is affected by AARTO? Now, I think everyone here has come on the webinar not in a private capacity, but representing a company or a business, and that's the premise on which we've developed the materials today. So the management within commercial fleet, or even within a normal business with a juristic entity, will need to really look at the governance systems in place that are related to driving behavior and the use of vehicles in the course of their business, or the use of vehicles for profit or an operator. So that'll be quite an important, I think, role management has to play to look at probably amending certain systems in order to make provision for the Act. And at the end of the session, we will talk about some suggestions for corporate fleets to consider or start considering in preparation for AARTO's implementation. Employees or drivers need to ensure that all private travel complies with the Act. So if you have a a driver, and he or she incurs demerit points in their personal capacity driving, to church on a Sunday, the demerit points they incur in their private capacity will impact on your commercial fleet operation if they are driving for you commercially. That's quite a new thing for us, and it's something which, as commercial fleets and as management, we need to start conscientizing our drivers about. If you are an operator or a juristic person, one needs to bear in mind that it's probable to incur demerit points on an operator card or on a license disc for specific vehicles, if you're a juristic person or an operator. Human resources will need to, I think, start getting their heads around amending and tweaking their HR policies to make provision for possible suspension or cancellation of driving licenses. Commercial drivers are obviously at greatest risk, since most of their time is spent on the road. Fleet controllers, in terms of, many of you know, Section 49 of the Road Traffic Act, which relates to the duties of an operator. So in this regard, the fleet controller will now, not the controller always, but the designated person who fulfills the function of ensuring vehicle safety will need to ensure the vehicles are safe and place a greater responsibility to only dispatch vehicles that are safe and roadworthy. And obviously, if you're driving as part of your, sorry, things happened there. So give me a second. I seem to have lost it on my side. Okay, can you all see it still? The presentation?
Yes, it's visible. Okay. Thank you.
Okay, thanks. If you're somebody who drives for your livelihood, and if your license is suspended, it could impact on your family. And of course, the responsibility for you and I is to change our mindset and behavior and adopt one of self-regulation. In other words, let's do the right thing on the roads, regardless of who's watching us, as a sustainable way to not just mitigate AARTO, but to actually protect our own livelihoods. And to be honest, and I'm deviating a bit here, but I think it's worthwhile, I always believe that selling AARTO to our drivers shouldn't be from a purely legal perspective. We should make them understand if they are non-compliant and engage in high-risk driving behavior, it's their own safety and the livelihood of the families that are most at risk. So that's just something which I believe strongly in, is in educating drivers from a perspective of seeing the benefit of safe driving on their own lives. So how does AARTO work? You're probably asking. Well, each offense carries a certain number of demerit points. So when a driver commits a traffic violation, demerit points are allocated to their driving record based on the severity of the offense. And here's an example of speed violations in different zone categories. And you will see on the extreme, well, on my left, I guess your left as well, the demerit points increase with increasing severity of the violation. So if you look at row number 5 and column number 6, if you are traveling at 160 kilometers in a 120 zone, just assuming you have a light motor vehicle, right? Not a heavy vehicle, then you will incur 5 demerit points, and you will also be liable for the traffic fine of a 1,500 Rand that's payable as well. You will also note in row number 6 and demerit point 6 allocated, there's no fine applicable to any of those offenses. So if you're traveling in excess of 40 kilometers per hour of the relevant road speed, then it is an offense that's deemed to be falling under the Criminal Procedures Act. You are liable to be arrested on the spot and face the subsequent prosecution. So if there's certain acts within Schedule 3 or the charge book as it's commonly known, that will incur the maximum of 6 demerit points and will also be prosecuted due to the severity of the act under the Criminal Procedures Act as well. The other example that comes to mind is driving whilst intoxicated. Yes, you will still be prosecuted and incur demerit points, but you will also be arrested should you be found to be to have been intoxicated or above the relevant legal limit. So we all will start with 0 demerit points, and as we engage in poor driving behavior, then we will accumulate demerit points, and currently the limit is set at 15. So once one acquires in excess of 15 demerit points, this is where severe penalties are imposed. So when we exceed the demerit point threshold for the first time, so if I'm on 16 demerit points, that means my license will be suspended, which I've shaded in yellow font there, S1, call it suspension 1. If I do that again, in other words, my license was suspended, and we'll talk in a minute, how does the points reduce? In other words, how do we get back in the green, if I can put it that way? But for every time our license is suspended, there is a sanction, meaning you cannot drive for 3 months for every point you exceed the 15 threshold. So if you're currently on 14, for example, and you incur a sanction with 3 points, that will mean 17, which is 2 points above 15, then you'll be suspended for 6 months. So that's essentially how the demerit point system will work in practice. But the third bullet is an absolutely critical one for us to know about. Once your license is suspended twice, on the third time, your license is cancelled. That means you will need to apply for a new learner's license and a new driving license all over again. That's basically the 3 severe sanctions. You'll have a suspension 1, suspension 2. On the 3rd suspension, your license is cancelled, and one has to restart the process as if you never had a license initially. So demerit, question now. Demerit points Ryan, sorry, I can't see the screen for some reason. And Rian, so if you guys see a hand or two, just make me aware of it. Demerit points are allocated against the driver, the person behind the wheel. It can also be allocated to the juristic person, in other words, a supermarket or a hospital or a business that's not a commercial operator, or obviously an operator, depending on the nature of the infringement. And we'll show you just now all the different types of charges under Schedule 3 or the charge book, and which ones. Typically, if the nature of the offence falls under Section 49 of the Road Traffic Act, then there's a double whammy. The driver gets the points, and the juristic person or operator also gets points allocated as well. As I've mentioned, demerit points, or sorry, maybe I didn't mention it. Demerit points are reduced by 1 point for every 3 months of, call it, good driving behavior. So if you're currently on 14 points, and for the next 6 months, you drive exceptionally well, you will then have your points go down to 12 in the second month, because it's 1 point reduction for every 3 months of good driving behavior. In terms of the Act, or the current provisions in the Act, you will be notified to hand in your driving license if you're suspended, obviously. And if you do not comply, you'll be fined a further 1,000 Rand and a 12-month suspension, and an additional 3 demerit points will be allocated. Can you guys still hear me?
Yes, Oliver, you're coming through clear.
Oliver, someone's hand is up.
Okay, sorry, I lost you for a few minutes. My internet connection dipped. Okay, I'm not sure whose hand is up, but please feel free to go ahead and talk. Okay. I must apologize. I'm not sure how long I lost you for, but on my side, it seemed to have dipped for 10 or 15 seconds. So I hope I wasn't talking to myself. Hand is down now. Okay, great. So I'm going to continue, colleagues. I hope you can still see the presentation. If not, please let me know. Okay, I just want to check something. Yeah. So a driving license is suspended should the holder accrue more than 15 demerit points. And for every point in excess of 15, suspension happens for 3 months, with the good behavior reduction of 1 demerit point for every 3 months as well. So if you've got 12 points and you commit an offense which has a 5 demerit point allocation, you'll then be on 17, which will imply 6 months suspension from driving. And you can see already, if you're running a commercial fleet and you have a few drivers who suddenly fall foul of the regulations, it could have a almost catastrophic effect on a commercial fleet operation. Hence the need to start conscientizing drivers and to start making, I think, strategic plans on how to create the awareness and other initiatives that will prevent these likelihoods from occurring. So the other provision in the AARTO Act is that drivers can complete a rehabilitation program. So if one goes through the rehab program, then your points tally is reduced by 4. So there's 2 options with the rehab program. One, you could opt to do it voluntarily, but you only have that option once in a 12-month period. The second one applies to those whose licenses have been cancelled. So if your license had been cancelled, in other words, you've had 1 suspension, 2 suspension, 3rd strike, it's compulsory for anybody with a cancelled license to undergo the rehab program. As I've mentioned, it's deemed to be a criminal offence to drive whilst your driving license is suspended or cancelled. I was going to say something, but I forgot. Oh, yes. Rion, do you want to just quickly comment about how that process will be enacted practically if one is suspended or the driving license is cancelled in terms of handing in the licenses and all of that?
Thank you, Oliver. Yes, I think that this can become quite a complex issue. First of all, when the license is suspended or cancelled, the Act currently indicates that the license or the operator card must be surrendered to the nearest registering authority, the driving license test centre, or the issuing authority in your residential area. Upon expiration of your suspension, those documents can either be collected or they will be sent to you by the institution that actually collected and held your documents for safekeeping. Once a driver's license is cancelled, I see a slightly bigger problem, especially for the older generation who obtained their licenses under the K52 system and not the K53. But before one can apply for a new driver's license, as you said earlier, Oliver, you will have to attend a compulsory rehabilitation program at your own cost. And only thereafter, once you've successfully attended the rehab program, will one be able to apply for a new learner's license. And then once you have your driver's license, your learner's license, apply for a driver's test. And obviously that test will be done in terms of the K53. And that could mean additional cost to the person because you may have to just go for some driving school lessons. So it is an arduous process, and one can find oneself without a driving license for up to 12 months and even longer.
Thank you, Rion. Appreciate it. I think there was a hand up. I think Sean, did you have your hand up, Sean?
Yes. Afternoon, Oliver and team. The question I had is who's going to store the data of the point system, and how would one access it? The thought comes when a driver's applying for a position, one would like to see how many points he has on his license, and is he got 14 points on his license and he's almost ready to have a suspension? Because I can foresee drivers hopping between companies. They'll be paid off with one company because he's either got his license suspended, or that he's on 14 points and he leaves because he's now scared of getting dismissed because of that and be moving to another company. How would we access that, and would the public have access to see how many points you have on your license, or how many points a prospective employee has? I don't know if that makes sense.
No, 100%. It's a very valid inquiry. Rion, do you want to comment? I've got a slide to show in that regard, but I'm not sure if you want to comment quickly, Rion, or are you okay?
Yes, I know you are going to get to that slide. Currently, the current legislation specifies a fee of 60 Rand for every inquiry that one makes pertaining to the validity of a driver's license or the number of demerit points. But I also know that there's a possible amendment to that regulation, which will allow certain categories of transport companies to pay a once-off annual fee to access the records of their employees and their drivers. And obviously, those that fall in a higher category who have more vehicles in their fleet will pay a larger annual fee to access that information. But I'm sure you're going to be getting to that slide. One has to remember that all this information is also governed by the POPI Act. So your personal information will not be readily available to anybody to access. Thanks, Oliver.
Thank you, Rion. Yeah, sure. Just to add on to that now, I think there's a slide later on. AARTO have, in principle, said they will allow a platform where a commercial fleet operator can register, and once he's obtained the required permission or authorization from the driving complement, will be able to access the database. I forget what it's called, National Offenders Register, I think. But they
The
will be
National
able to
Offence
access,
Register.
sorry?
The National Offence Register.
Correct. National Offence Register. So they will be able to interact with AARTO and have a look at all the drivers at what status they have in terms of demerit points. I hope that answers your question, Sean.
Yeah, thank you, Oliver. I think you have. Sorry if I was premature in my question. If there's a slide to follow, then...
No, it's fine. Sometimes it's best to ask the question so everyone remembers it better.
Oliver, can I just add something there, please?
Sure, go for it.
I think it's critical as operators and managers of transport organizations that, and Oliver, I know it's also a slide that you're going to be getting to, but it's going to be critical that one obtains the permission of the relevant drivers to access their personal information. So Oliver will get to that stage where we give advice to operators on how to amend their employment contracts, etc. But it's going to be critical that one gets the authority or approval from the driver for the company to access his driver's license status, the validity thereof, the number of demerit points, both in his official capacity and his or her private capacity. Thanks, Oliver.
Sure, thank you, Rian. John, please go ahead.
Hi, Oliver. Just a question on the rehabilitation program. So is that going to be administered by private companies or is that Department of Transport? I heard it was mentioned that that's going to come at a cost. I was just wondering, do you go to the traffic department and you can do the program there at a cost, or is it, let's say we don't have a private service provider that provides that service, do we have to travel somewhere to go and get the rehabilitation or let our drivers do the rehabilitation program?
John, as it stands, the current regulations mention the rehab program and mention the 4 points associated with it. It gives no further guidance, as far as I'm aware, in terms of what the content will be, who the service provider is, what the costs are, and what platforms it will be available to those who need to access it. So we are all, like you, eagerly awaiting the promulgation of the revised regulations in the fervent hope that they will define that. Because right now, and that's more than likely, in my mind, one of the reasons why it seems that phase 2 has now been delayed, because they haven't quite done the framework for the rehab program yet. So unfortunately, John, I can't answer that with much clarity, purely because there's no guidance in the current regulations.
Okay, thanks.
But as soon as we hear something, all of you attending will be now put into our MailChimp database, with your permission, of course, in terms of PAPIA. But you will get a notice requesting authorization. And once you are happy, you will receive any comms in terms of developments further down.
Thank you.
You're welcome. So in terms of demerit points, I think I've mentioned this, but just it's a summary slide. So if you're a driver in your private capacity or professional, the demerit points in that context will accrue towards one's driving license. If you're a juristic person, such as a university, hospital, school, etc., and obviously not registered as an operator, the demerit points will accrue towards the vehicle license disc. And if you're an operator, it will accrue towards your operator card. So there's a potential for a vehicle to have the license disc cancelled or the operator card cancelled. And we'll show you in a minute or two which offences could result in that eventuality. So this is Schedule 3, if I can call it the dreaded Schedule 3. There's around 2,500, I think, different types of offences. You'll see there's a whole lot of information there, but the important ones for our purpose is just to look at the actual nature of the offence and on one of the columns on your right, the demerit point and the rand value penalty. So there's 2,500 odd of these, and each of them will have a different level of severity and a different allocation of points and financial value as well. And it covers all aspects of road traffic legislation, including equipment in respect of motor vehicles. So this talks to roadworthy vehicles and safe vehicles. It includes things like, for commercial fleets, which is important, overloading. And interestingly, for those of you who are in the heavy vehicle fleet, you'll see in row number 1000, if you're loading a truck, a normal link, and if you exceed by 14% or more, then that's deemed to be a criminal offense. And yes, you will still incur, I'm not sure if you can see my cursor, but you will still incur the 6 demerit points. But in addition, you will be charged under the Criminal Procedures Act as well. And though there's quite a few of those, the demerit points typically range from 1 up to 5, 5 being severe offenses, but any demerit point allocation of 6 infers it is a criminal act and will be prosecuted under the CPA as well. So just as an example to solidify what I've mentioned, excuse me a sec, I'm just having a slight problem on my screen for some reason. Okay, I fixed it. So as an example, if you commit an infringement by having number plates fitted to your vehicle that are not visible, then you don't commit any offense for the next 3 months. Thereafter, the driver is caught for speeding, another offense, stop lamps are defective, and he was found to drive without a valid PDP, and he was found to overtake on a blind ride. So let's look at that scenario and what the potential impact would be. This obviously isn't the driver from all of your competitors.
Were you on mute?
Sorry, can you hear me now?
Yes.
Oh, my apologies. Was I talking to myself? Sorry about that. Let me go one back then. Okay, I'm going to turn off my camera and see if that buys me some goodwill. Okay, so just confirm that you can see the screen with the slide showing infringements in red and 1 green shade. We all on the same page?
Yes, Oliver. Thank you.
Okay, so just to go back. So this driver is obviously not a good one. He or she has had a number of offenses. You'll see they've had the first offense, number plates not clearly visible. They incurred 1 demerit point. They were good for the next 3 months. Point was reduced, and then they were bad for the next number of weeks or months, whatever it may be. And they've accumulated 16 points in total, which is 1 above 15, and that would imply they are now suspended for 3 months. If they had incurred, say, 18 points, they would have been suspended for a 9-month period. So that's really the scary part, I think, for commercial fleets. If they have a high number of highly non-compliant and negligent drivers, there could be severe impact. Oops, sorry about that. Okay, so here's the example I was talking about earlier. You'll see on the left-hand half of the slide is the impact on the individual driver of the vehicle. And on the right-hand side is the impact on the operator or juristic person. So in the first example we used, the driver did not have a PRGP or didn't carry one, whichever it may be. He or she would incur 4 demerit points. and they would pay the rand value fine. There's no impact on the operator because that was a negligence on the part of the driver entirely. So there's no action taken to the juristic person or the operator. But the second offence, where the stop lamp is not working, the driver incurred 4 demerit points with a rand value of 500, but the operator or juristic person also would incur 4 demerit points that will be allocated to their either license disc or operator card. So that's the same would apply to the lack of contour markings on the truck or vehicle. Because it's a Section 49 offence, it has a double whammy. The driver incurs points and the juristic person or operator as well. The next one, driver did not stop at the stop sign. That is only impacting the driver because the company could likely not have done much about that bad behavior. Sean, please go ahead. I see your hands up.
Thanks, Oliver. So I know I'm interjecting again. So what I'm concerned that AARTO is saying that you deemed to be guilty of the offence, presumed to be guilty of any offence. So the stoplight issue. So what now we can prove when the truck did its pre-check inspection with the dispatcher, we have we did a vehicle check with the dispatcher and we confirmed that the brake lights were functioning and working when he started the trip. During the trip somewhere, the brake light malfunctions. So we can actually prove that before he started the trip, the driver and the controller or supervisor or whatever did the vehicle inspection together. He has a document where they signed an inspection sheet and the vehicle was in a roadworthy condition when it left the depot. On the road, heat, cold, whatever, the filament blows on. Okay, most of the globes are going now to LED, but take it for the filament or globe malfunctions whilst you're on the trip. Now the traffic cop stops you. How do we get around that? Because we deemed to be guilty just by reason of us driving the truck. How would we think about that one?
Rian, this is up your street. I'm going to leave you to it.
Yes, thanks, Oliver. And Sean, thanks for the question. The process, the AARTO process, makes provision for you to submit a written representation to the representations officer at the RTIA, obviously within a certain time frame, together with the evidence that you may have in terms of your pre-trip inspection or any other document that you might have. And I'm sure once they've received that written representation, they will consider the matter in your favor. What's also important and what I'd like to see within the law enforcement environment, that should a traffic officer or a police officer be presented on the road with such documents, that a certain level of discretion is being used. And I don't want to open a huge debate now on discretion, but I would imagine that is how one would like a law enforcement officer to react upon viewing the documentation that you refer to, i.e. the pre-trip inspection. But it has also come to our notice during various audits that we've done, and drivers often complain that they've identified certain defects on the vehicle before leaving the yard, and the workshop manager is too busy to correct those defects. So as Oliver said earlier on in the presentation, we need to also respect the rights of the driver, and in many instances, certain companies will either reprimand the driver. In certain instances, we've heard that drivers have been dismissed because they refuse to take an unroadworthy vehicle onto the road. So all those aspects need to be considered. But to answer your question, there is a representations officer to whom you can make written representation together with the relevant documents and proof that you might have for their consideration.
Thanks. That answers my question, and I agree with you. There are many times where drivers are forced to do stuff, but I think the whole concept just means that there's going to be more emphasis put on the operational staff to perform and to make sure that the trucks go on the road in the best condition possible. So I think the whole mind shift is a fantastic concept. It's going to make road safety fantastic out there. Yeah, but it does answer my question. Thank you very much.
Thanks, Sean. And I will, in a minute or two, I think, share the representation form and what the process is to make the representation. Should you believe that you've done due diligence and all that you could have possibly done, then you have that opportunity. And I'll share a slide in a minute or two around that process. John, I think you had your hand up just now. I think I saw it briefly.
Yeah, it's just a follow up on Sean's question. So if you have a driver that has already got 14 demerit points and there is now this issue with the stop lamp not working, and so now he goes to 18 and it's a 9-month suspension, but the company is doing a written representation, will they hold off with the suspension until the outcome of the representation, or will the suspension still be enforced until the time that the representation outcome is given to the company or made official?
Rion, do you want to take that one again?
Thank you, Oliver. Yes, so what happens is that there are certain stages when the actual demerit points are applied. And I'll just go through them very quickly. So once the penalty is paid by whoever, the driver or the operator, the points are immediately accrued to either the operator or the driver. Should you apply to pay in installments, the same applies. When you submit a written representation, the points are allocated. So that answers your question. As soon as you submit a written representation, the points will be allocated.
So will they then give time for the driver to hand in his license, or would it have to be immediately?
No, they will. The RTRA will advise the driver or the operator what the status of the written representation is, what the status of the demerit points is, and then issue you with a document to state that the driver's license or the operator card must be handed in to the nearest registering authority, the issuing authority, or the driving license testing center. So they will notify the operator or the driver.
So, for example,
Yes,
they would maybe say you have 7 days to submit the card, unless otherwise you will get that additional fine and additional suspension. Would it be something like that?
Yes, absolutely. That is correct.
Yeah, 100%, John. I'll show you later on at the end of the session. So AARTO is extremely document driven. Nothing happens without a written notice, either from the driver to AARTO or vice versa. So for any actions to be taken, it can only happen in terms of the act upon a notice being issued. So nothing will happen to the driver without that notice. So you will have a clear notice saying, Mr. John, you need to hand in your license within 7 days from the date of the notice. And that's, I think, the one thing that's clearly come across. Very document driven, very notice driven. And sadly, there's admin fees all along the way for each notice, which I'll share in a minute.
Thanks.
Okay, just just for completion purposes, when the Amendment Act was promulgated, the initial one that is, there was a phased-in approach that was going to be applied. Phase 1, they said, would be for high-risk infringements, your typical what we call moving violations, and that's a list of what you see: speeding, dangerous overtaking, hazardous driving, etc. I'm going to skip through this quickly because it's not really that critical for us in terms of what we want to achieve today. Phase 2 of the AARTO implementation was going to incorporate issuing infringement notices for those offences that have an economic significance, which includes protection of the roads, overload control, operating licenses, and offences related to the transportation of dangerous goods. It will also include your typical TRH11 document that looks at abnormal loads and how do you operate legally within the abnormal load environment. But we are not sure if this approach will still be what they have in mind with the soon to be promulgated amended regulations, but we'll wait and see. And phase 3 was going to be offences that are mainly related to administrative issues, failure to update documents, addresses, and the like. So that was just the indication that there'd be a phased-in approach for implementing infringement based on the offences. Okay, this one, we had to put it in here because it's one of the most common questions that we're asked. Do foreign drivers get demerit points? And based on the last regulations, the answer was no. Okay, so now we're going to look at the actual documents. Now we're understanding the principles of AARTO and how it will be implemented. Now we're going to talk about the documents, and I have to warn you, there are tons of documents in AARTO. Nothing happens without completing a document. As I mentioned, an infringement notice is issued for all offences that are related to the AARTO Act. And if there are offences that fall under the Criminal Procedures Act, it's dealt in terms of the CPA, as it currently is the case. So when you are being issued with an infringement notice, it could happen if you're stopped by a traffic officer. It could be for a parking infringement and you're not in attendance. In that case, the infringement notice must be issued and served within 60 days. When the infringement is caught on camera, the Act or the regulations state the infringement notice must be issued and served within 60 days. That's just for your knowledge to know what are the legalities around issuing of infringements. Now, here are some of the forms. So every correspondence in AARTO has a AARTO numbered form. AARTO 1 is issued at the roadside. So you're speeding or at a roadblock, you serve with the notice in person. AARTO 2 is issued at the roadside, but it could be served in person or by other means. So they could serve it to you via WhatsApp, text, social media even, from what we're given to understand. AARTO 3 is issued by electronic means or by mail to registered owner, and AARTO 31 is placed on the vehicle windscreen in the case of an unattended vehicle. And you obviously need to be aware that any infringement notice in terms of legislation will need to have, or need to include rather, all those important pieces of information: correct name, registration, the amount of the penalty, where to pay. The infringer must be informed that they ought to pay within 32 days, and I'll talk about the discount applicable in the next slide. So all of these particulars will be typically on the notice served to you should you be an infringer. So once you've received the infringement notice, the current provision is if you pay within 32 days, you enjoy the benefit of a 50% discount, not on the demerit points, but just on the rand value. So you pay the fine, the points are allocated to the driver's name, and the process is complete. Well, not complete, but I mean, the payment process is complete anyway. So in this case, you paid the fine, the demerit points are allocated, and here, John, as I mentioned, the authority will inform you in writing of the points allocated recorded against the National Road Traffic Offences Register. So you will get a notification of that event. Should you, for whatever reason, ignore the infringement notice issued to you in whichever means it was issued, then you'll be given the courtesy of a courtesy letter. So AARTO will send you a letter stating that you've not made payment within the 32 days. You are reminded, you will be reminded to pay, and you'll now be liable for the full amount. The 50% discount will fall away. In addition, there will be an infringement penalty levy for the issue of the courtesy letter, which currently is 100 Rand, if I remember correctly. The purpose of the courtesy letter is to inform you that you failed to pay the infringement notice and inform you to pay the penalty in full and to also pay the $100 for the infringement penalty as well. The next question you ask is, what happens if you ignore the courtesy letter? Oh yeah, I mustn't forget. The point at the top in yellow shades is an important one. When you initially receive the infringement notice, obviously it wasn't handed at the roadside, but you receive it via mail. And if you were not the driver of the vehicle, it's critical that you send AARTO on the form, which I'll show you now, the form to confirm you are not the driver, and you nominate the driver who was in operating the vehicle at the time of the offense. So that's absolutely vital. So if you're a massive fleet with 500-600 trucks, you'll need to have a system that knows which driver is driving which truck, at what time of day, how are you doing handovers, etc. Or you run the risk of having demerit points accrue to the innocent drivers, as it were. So nomination is critical at the outset. If you don't nominate the driver, once you receive the infringement notice, you've got no further opportunity to do so. It's assumed, if you don't nominate, that the driver who it was issued to is in fact the guilty person, if I can put it that way. So if you fail to pay within 32 days, you ignore the courtesy letter that was issued to you, you will then be issued with an enforcement order by AARTO. The enforcement order will be issued and you'll be notified of the number of demerit points allocated against your name, the total number allocated or accumulated rather to date, and number of points left. So that's what the enforcement order will notify you of. At this stage of proceedings, you're now required to make a payment of the penalty in full, whatever it was initially. You'll still be liable for the representation fees of 100 Rand, fee for the, if you had opted to go that route. If you ignored the courtesy letter, you'd still be liable for the fee of 100 Rand, plus the fee for the issue of the enforcement order, and all of that will need to be settled within 32 days. And you can see clearly here already that, the intention is really to get you to pay up front unless you really are not guilty or you haven't committed the offense, then you'll issue representation in that regard. Once the enforcement order has been issued, all your e-Natus transactions will be blocked. So you will not be able to renew your driving license, apply for a new license, renew your vehicle card, or your operator card. So the system is designed to kind of force you to pay. If not, it looks like, from what we're seeing and what we've seen today, it will be quite frustrating and expensive to prove your innocence rather. The representation I'll cover in a second, because I think there's huge potential, as is currently the case, with camera fines, to have fines issued incorrectly with the incorrect registration number. So we'll look at how do you represent yourself or your employees if an infringement notice is issued and you're clearly not at fault, or in Sean's example earlier, you have done due diligence and you've got evidence to support the fact that you operated the vehicle safely and you can make those representations provided you have documents in support of your case. The last point to note there is quite an important one. No driving license, operator disc, or vehicle license disc will be issued on the NATA system until all penalties and fees have been paid. So you could have an enforcement order revoked. And again, as I mentioned, document driven. You can apply to AARTO using the prescribed form for the revocation of the enforcement order. You've got to obviously put in motivation and reasons as to why they should consider your application. They will then apply their minds to it. And if they do agree with you and they revoke the order, then it reverses whatever damage may have been done, which will typically cancel any fines or points allocated. The National Road Traffic Offences Register would be updated. And again, you'll be informed on a document from the RTIA. And if you had handed in any license, PRDP, or operator card, these will be returned to you. Okay, I've covered this, but I'll just quickly summarize again. So there's a couple of different ways in which notices can be served: in person, by post, electronic service via even social media. And the fourth bullet is an important one. In all cases, except if you handed the notice in person, so in all cases except that, the notice is deemed by the regulator to have been served on the 10th day after sending, unless, again, you prove that to be to the contrary. So that's an important one to remember. Okay, we've covered this already, but I will just mention it. The duty is on the motorist to act, and failure, can have severe impact. So we are deemed guilty until we prove ourselves innocent. Okay, so just to summarize the payment process, you can pay within 32 days and you will enjoy the 50% discount. You could elect to pay in installments within 32 days, and you fill in the AARTO 04 form requesting that. Rian, I think you still enjoy the privilege, or the benefit rather, of the discount if you apply to pay installments upfront. Do you? I just can't remember now, but anyway, I'll confirm that just now.
Oliver, yes, once you've applied to pay in installments, you lose your 50% discount.
Okay, thanks, Rian, appreciate it. Okay, so if you do apply for installments, you would lose the discount, so sorry about that. The nomination of a driver happens in AARTO 7. Written representation happens in AARTO 8, and I'll show you one or two examples of those forms. So as an employer, you can only have access to your driver's points with their permission. We spoke about this both in terms of the POPI Act, but also in terms of AARTO. And you've got to complete either AARTO 27 or AARTO 28 to formally lodge that complaint with the RTIA. The fleet user interface, I think Sean's question earlier, they've made, or they are making provisions currently, I must be careful how I word it. Provisions are currently being made to make available to juristic persons and operators on application for engaging efficiently on the status of demerit points. The indications are that if you have a large fleet over 100, it will be 11,200 per annum, or if you pay it in a 6 monthly period, you pay a bit more. So that will allow you to interface with the National Traffic Offenders Register and have an almost live system to track which driver is currently on how many demerit points. Okay, so this is just, again, a bit of a reminder for commercial fleet operators that they still have all the normal duties and responsibilities under Section 49. things like ensuring protecting the operator card, to ensure it's displayed in the window, controlling the driver's behavior, vehicle fitness, and if you're in the dangerous goods space as well, to ensure that the relevant standards are applied. For dangerous goods, it's typically SANS 10231 that governs the operation of dangerous goods vehicles. So all of these have not changed, but obviously we saw earlier it places an added responsibility now with the potential for vehicles being suspended. So this is the form that one will need to use to make a representation to the RTIA, and the forms all look very similar. They're different colors, and we can send, in fact, Ryan, we will just send a list of all the forms to all the delegates after the session is done, so they have it on record and know what it looks like at least. So when you make a written representation, attach the evidence, and the RTIA will then request for an officer to consider your application. And you can make representation at any stage before the enforcement order is issued. But once the order is issued, you don't have that option any longer. But for each representation, it's 100 Rand admin fee plus whatever you need to submit as well. Yes, John, go for it.
Oliver, just a question. I don't know if you're going to get to it. Is there a possibility that a specific vehicle in your fleet has that vehicle's license can be suspended and that you can't operate for 3 months with that vehicle? Is that not possible?
Currently, yes, very possible. Under the existing regulations, if the vehicle or the driver, I can't say the vehicle, if the driver incurs a fine or an infringement notice that has a Section 49 demerit point allocation, and that vehicle accrues more than 15 demerit points, then the vehicle will be suspended and not allowed to operate for 3 months per point in excess of 15. Yeah.
Okay.
Okay, maybe I shouldn't say it, but I think it's somewhat unfair. But okay, I'm not going to say it because
Yeah, so
we can go to a long debate about that.
So you can basically have the driver that committed the offense still in your employ because he's now moved to another vehicle, and you have another driver on this vehicle, and he gets points, and the truck can get suspended while the drivers, there was maybe 5 or 6 different drivers that got points on that specific vehicle.
Yeah, one of the contestations, John, is that how can one allocate a sanction on an inanimate object? But we can talk long and hard about that for sure. But I think it's in the Act, and as it stands, it will be implemented.
Okay.
To be honest, between you and I, I'm hoping that the new regulation, when they're promulgated, will not have it in, but it is there at the moment.
Okay.
Okay, so this is all about RTIA, and yes, Sean, go for it.
Yeah, sorry, me again. Oliver, is there time frames that get indicated if you want to make these submissions and stuff like that? Because obviously, if you're saying the licenses are suspended for the driver or the truck, there's financial implications on the transporter. Now you have a truck that can't move because its license has been suspended, or a driver, and you're going through this process where you've made a representation. What type of time frames have they indicated will come back? Is it what turnaround times do you have? Are we going to be drivers sitting for weeks and months on end waiting for RTIA to come back with confirming the representation and cancelling and putting your points back? Because obviously that's quite an implication. Your driver's sitting, not work on the road, and if it takes 3 months for them to come back with a finding, that would be unreasonable. Is there some type of indication of time frames?
There are time frames indicated in terms of submission of representation, etc. But I'm going to pass this difficult question again, like I promised at the beginning, to Rion. Rion, do you know, are there any commitments made from AARTO in terms of their response times? That's most concerning, I think, to all of us.
Yeah, absolutely. When interrogating the current regulations, I did not find any evidence of a time frame imposed on the representations officer to respond to any written representation. And that's obviously a very grey area, as Sean has pointed out. And hopefully with the new regulations that could be addressed. But it is a matter of concern. Thanks, Oliver.
Well, yeah, thank you. Because without sounding to be the defeatist, we know how government organizations and stuff like this work, and how they not speedy in their executing of their duty. So that's why I raised that concern. Yeah, but thank you for the response anyway.
Yeah, Sean, it's a valid concern, but yeah, unfortunately, there's nothing in the Act or regulations that provide any guidance around response time. And yeah, I think we at the mercy of the authority. Okay, we've covered this. So if you make representation and you are successful, then it will cancel the infringement. Sorry, I beg your pardon. Sorry, this is a different slide. If your representation is successful on the grounds that the AARTO document was not lawfully served, so they made a mistake, perhaps with a digit or a number or something on a technicality, it does not cancel the infringement. The issuing authority may reissue the document and serve it lawfully, provided it's done within 6 months of the alleged infringement. Okay, that's part of the regulations. I've spoken about nominating a driver. It's going to be absolutely vital that one nominates a driver as soon as the notice is issued and you have it in your possession, and the form to use there is AARTO 07. Then the issuing authority, once they receive correspondence in that regard, they will inform you in writing on an AARTO 07A form that they've received your nomination and they've accepted it, and then it will then take, the process will then start going ahead as per the normal procedure once the driver's identity has been confirmed. There is provisions currently for an appeals tribunal. So here, this would apply to situations where you've lodged a written representation with the RTIA. It was rejected by the representations officer. You've received a rejection form, AARTO 09B, and you will then have the option of appealing to the the appeals tribunal. And they will then consider if there's any good cause shown that they might consider the appeal based on the merits thereof. So the appeals tribunal may confirm or set aside any decision which has been lodged. And if there's sort of no clear majority, the chairperson of the committee will make a casting vote according to the regulations. I think it's common knowledge, though, probably one of the reasons why the delays happened is because the appeals tribunal have not yet been appointed. I saw a few months ago in the Sunday Times, I think, the advert went out for nominations to serve on the appeals tribunal, but I guess they haven't yet made those appointments. Okay, so this is, Rian, you're going to comment now because you told me something yesterday which also surprised me. Currently, as it stands, if you do not agree with the decision of the tribunal, you could have approached the magistrate's court to review the decision within 7 days of the appeals tribunal decision. But Rian, you mentioned this may not be an option in the new regulation from what you've heard.
Thank you, Oliver. I think this is one of those grey areas that needs to be addressed, and the specific processes and procedures that will have to apply in order for one to elect this option. Now, currently, in terms of the criminal justice system, which obviously doesn't apply to Tshwane and Joburg, and I think Ekurhuleni, in order for a person to appear before a magistrate in a court, the Criminal Procedure Act prescribes certain procedures in getting a person to appear before a magistrate, and that's by means of Section 56, which we all generally know as a summons, or Section 54, which could be issued at a roadblock by a traffic officer or by a court orderly, and those are or by arrest, and those are the only methods currently available to get somebody to appear before a magistrate in a court. So I think we'll have to await amendment or more information in the new regulations as to exactly how this option is going to work. I know that in Johannesburg and in Tshwane, this has been one of the biggest issues initially with the rollout of AARTO way back in 2008, where people saw this loophole and thousands of people who received infringement notices applied to appear before a magistrate's court, and those processes had not been defined, which meant that the infringement notices were withdrawn. So this is a grey area, and it needs to be given a lot of attention and a lot more detail as to exactly how this is going to work.
Thanks, Rian. Yeah, one of the things with legislation, and we see it in other areas, I'll give you an example, a good one actually. With the consignee regulation, which was promulgated in 2013, 2014. And those regs said, if a consignor or a consignee is offering more than 60 tons of goods for transport, and if the vehicles are found to be overloaded, then those consignors or consignees will be prosecuted under the Criminal Procedures Act. That was, 10 years ago. Since then, there's not been a single case or precedent where it's gone to a court. And I think with legislation, sometimes the only way to test it is when an actual precedent occurs that helps guide all of us in terms of how will the process unfold, how will the courts view it, and that's pretty much what we hope will likely happen. But yeah, there's lots of gray areas there in not just AARTO, but I think a lot of legislation that we find ourselves confronted with. So sorry we couldn't answer you directly there, Sean, but I think we'll see what happens. Okay, then we're almost at the end now. We've got half an hour, and just if you have any questions, we've got half an hour left to discuss and to debate around that. Okay, so just to conclude, AARTO has 3 schedules, the regulations attached to it, Schedule 1, 2, and 3. Schedule 1 is the list of the forms. Schedule 2, sorry, I'm confused now. Schedule 3 is the charge book. Schedule 2 is the fees. Oh, Schedule 1 is the administration forms, right? So we will send all of these to you post a session, just so you have it on record and are able to refer to it should you need to. Okay, my screen is really acting up today, so forgive me if I look confused. I can't see things as I normally would like to, so I'm betting to see. Okay, so this is a list of all the different letters and the penalties applicable for the correspondence actually. So it can be quite expensive if one goes the whole route of not paying initially or even making representation. So it's somewhat unfair if you think about it. If you are not the driver, or if you didn't commit the offense, you still have to pay the fees to clear your name, but that's how it is. Okay, so to conclude, I think we just want to chat a bit about the impact of AARTO, especially on the bigger fleets or commercial fleet operations, because the potential impact could result in driving license suspension or cancellation, could result in vehicle license discs or operator cards being suspended or cancelled. Mismanagement of traffic infringements could have a severe impact on a commercial fleet, in addition to private drivers as well. So part of what we hope to stimulate is discussion around, based on your own business model and context and operations, look at things like your employment contracts. Do they currently include performance and disciplinary thresholds in terms of AARTO? If not, you likely need to revise those and to also make provision for AARTO. So those disciplinary codes typically fall under the Labour Relations Act. So AARTO doesn't make any provision for HR issues, but you need to make provision for it using your procedures that you currently have in place. It could include written agreements with the drivers to authorize the company, and there are forms for that. One could also be thinking about incapacity procedures for employees whose licenses have been suspended or cancelled and who may not be given other work. Maybe there's no other opportunity for them within your company. How would you handle that? Where you've got an incapacitated employee that's on your pay, your salary bill. Sharon, is that you? Yes, there we go.
Hi, Oliver, thank you. I just want to ask one question. Obviously, if we get written agreement from the driver that we can access their demerit points, etc., if the driver's approaching his threshold, are we also allowed to institute warnings and disciplinary processes, warning the driver that he's on the threshold of getting his driver's license suspended?
100%, Sharon. I would recommend you do it more diligently than ever in light of the potential impact. So you absolutely should do that. Monitor and take action as early as possible to avoid the potential negative impact of suspension or cancellation. So definitely agreed.
Thank you, Oliver. Thanks.
Sure. Okay, yeah, well, Sharon's alluded to the next point. Drivers to be held accountable to immediately declare any notices they have received or criminal offences they may have committed, whether in the official or private capacity. But once you've got the authorization signed, you would have access to that information from the National Register. Administratively, you'll need to have a process for recording any traffic infringement notice issued to the company. Currently, if you are RTMS certified, you would know it's a requirement already to ensure every single traffic fine issued is recorded, categorized in terms of what was the nature of the offense, which driver was involved, was it a vehicle technical issue, was it driving behavior, was it tires, was it, so it's about categorizing these offenses to understand what are the root causes and then take actions to mitigate recurring issues that will have negative impact. So that's something to consider. Regular verification, we've spoken about it already. If your drivers have committed the offense, pay it within 32 days to get the 50% fee reduction, unless you believe strongly that you are not guilty, or there's information like what Sean mentioned earlier that you believe you've got grounds to stand on, then by all means, go ahead and make representation. You should respond to courtesy letters within 32 days to avoid incurring the enforcement order. Because once that happens, there will be a block on e-NATIS renewals from there. Okay, the critical step, and something which we've put in there, well, we've just made note of it rather, after talking to a number of fairly big fleets that are thinking about having a standby pool of drivers and vehicles. Now, in today's world, who can afford to have a standby fleet of vehicles? I think impossible, right? With the economy and the economic impact of even one vehicle standing. But nonetheless, one should think of mitigations should the worst happen. Ongoing driver training and mentoring to be integrated into the company operation. And here I would say implement road safety, implement good driving behavior, vehicle check, tire management, etc., as an integral part of your business, which will make it less likely that you'll incur these demerit points of business. And a key part of that is empowering, mentoring, and training of drivers, not just academic training, but using various initiatives to create the environment that makes them want to have or want to change their driving behavior on the road. Okay, AARTO forms Schedule 1. Sorry, I'm not sure if you can still hear me. Sorry, my network dropped there again for some reason. My apologies, but we're nearly done. So AARTO forms are in Schedule 1, and you can either download that from the AARTO website, or you can drop us an email and we'll send it on to you. That's just a list of all the AARTO forms and what the intended purposes are. Again, we'll forward this information to you. There isn't much point in going through each one in detail, but you can see, I think John asked the question earlier, it's very document driven. So for every form that you submit, there's an alternative form that ARTIA or the issuing authority will have to submit to you in terms of notification, etc. Then finally, you can register as an individual driver on the AARTO website. I tested it yesterday just to make sure it's still in operation, and I was able to log in with my ID number, and thankfully I had a clean bill of health, nothing on the system in my name. So you'd log in to aarto.gov.za, you'll go through a couple of forms, plug in your ID number, your name information, mobile number, email. They'll send you a one-time PIN. You create a password, and then from there on, you can pretty much log in your personal capacity and check what your demerit point status is. It was actually surprisingly easy compared to some of the other government platforms I've operated on. Okay, so thanks very much. I hope that's sort of given you of what AARTO is and what the main aspects one would need to consider in preparing for it. Rian, I'm not sure if you'd like to make any comments before we open the floor for questions or comments.
Can you hear me?
Yep, loud and clear.
There was just one issue, and I think one mustn't underestimate AARTO and how it's going to impact on operators. But there's another role player that we haven't discussed, and that's the insurance industry. And I'm sure the insurance industry will have a serious look at the validity of the driver's license, PRDP, and the operator card of a specific vehicle in the case of a claim. So I think we just need to bear that in mind in the back of our heads, that could also have an impact on how we conduct operations. Thanks, Olu.
Yeah, thanks, Rian. Actually, really important point. I've often worked with a colleague of mine at the RTMS National Committee, Steve Cornelius, and he's very honest. You know, he says an insurer will look for a reason to repudiate one's claim because they're not in it for, they're in it to make a profit. So I think one has to be quite aware of the insurance potential in terms of repudiation of claims if there are issues around AARTO and non-compliance. Okay, so that's about all we had hoped to share with you today. I certainly hope you found it meaningful, but we really want to improve the session and make it more value adding. So if you have any ideas or suggestions or comments on how we can improve it, please feel free to drop us an email or even in the chat. But my colleague Ryan will share the presentation with you in a PDF format and the forms, etc. And he will share a feedback form. So you're more than welcome to provide us feedback to help us improve the session and really help prepare the industry for what is coming around in the future. So over to you, colleagues, for questions or general comments. Okay, I'm guessing silence is golden, so we can all have a bit of a coffee break and spend the next 15 minutes catching up on our quickly backing up emails. So thank you again. We'd like to sincerely thank you for attending the session. We appreciate you using our service to help you in this area. And post-session, if you have any inquiries, Rion is pretty much our road traffic expert, providing support to our national client base, and he'll be glad to assist you further. So if there are no other questions, thank you all very much and have a wonderful afternoon. Thanks. Bye.
Thank you.
Bye, everyone. Thanks, Oliver.
Thank you, everyone.
Thank you, everybody.
Thank you, guys, and thank you for entertaining all my questions.
You're welcome, Sean. Questions are how we learn, right? So it's always a pleasure to engage with you. And I'm looking forward to our coffee. I haven't forgotten about that.
Yeah, let me know. Let me know. Maybe I must pop up to the office and meet your team.
Yeah, you're welcome anytime.
Yeah, sure. Thanks, Oliver.
Okay, take care.
Yeah,
I'm sure you'll be busy today with inclement weather in KZN, hey?
Yeah, we've got another couple of projects on the go as well. So yeah, it's been a bit of a busy time for us, eh?
Okay, Sean. Well, make sure you're taking off your own fatigue, like I said to you the last time.
Yeah, 100%. Cool beans.
Okay.
Bye.
Fantastic. Ciao, ciao.
Bye.
Oh, yeah.
Oliver, you still there?